Distinguished guests, ladies and gentlemen, good morning. I would like to take this opportunity to welcome you all to the first International Conference on Law with Sustainable Development and ASEAN's Perspective. We are truly honored to have highly noted speakers and top-notch panelists joining us today. This year, we have selected one of the most pressing topics as our main discussion theme, and that is the issue of sustainable development, looking from an ASEAN's point of view. ASEAN, or the Association of Southeast Asian Nations, is gaining considerably in importance as a trade bloc and is now the third largest in the world after the European Union and the American Free Trade Association. Comprising the ASEAN tigers of Thailand, Indonesia, Malaysia, Philippines, Singapore, and Vietnam, also known as the ASEAN Six. With the smaller players with Brunei, Cambodia, Laos, Myanmar, it has a combined GDP of $2.31 trillion in 2012 and is home to over 6 million people. With sustainable development, it is undeniably the central challenge of our time. Sustainable development is both a way of looking at the rest of the world with a focus on interlinkages of economic, social, environment, legal changes as a way of looking and describing our shared aspirations for hope of better life, combining economic development, social inclusion, and legal aspects together. As the concept of sustainable development has come of age, and we have undeniably entered a new era, and as a global society is interconnected as never before, it is critical that we apprehend the actual magnitude of the current climates we are facing. And it is of utmost importance of us to understand how we, as a lawyer and legal scholars, can help contribute towards such goal in practice on the ground in all parts of the world, more specifically in ASEAN and especially right here in Thailand. On this regard, I would like to invite Professor Banjert Singhaneti, Dean of Graduate School of Law, to give us a welcome remark upon the commencing of this conference. Ladies and gentlemen, please welcome Professor Banjert Singhaneti.
Vice President for Research and Consulting Service, Associate Professor Dr. Kampon Panya Gomez, distinguished participants, ladies and gentlemen. It gives me a great pleasure to welcome all of you. The opening ceremony this morning to the first International Conference on Law for Sustainable Development, an ASEAN perspective organized by the Graduate School of Law, National Institute of Development Administration. The significance of law for sustainable development is well noticed by several international networks, including ASEAN or Associate of Southeast Asian Nations. Law has played an important role in political, economic, and social development in the region. They examine the relation between law and development and analysis how to use law as an instrument to promote economic development, democracy, and human rights. This ensures that with the changing world, the law is not violated. At the conference, scholars in legal and interdisciplinary study and those who have worked in the area of law and development will present their research review article related to the major theme. This will be beneficial to academia and professionals, both nationally and internationally. Today's conference is consists of significant parts. First part will fulfill with honorable keynote address by Dr. Thanesh Sucharigun, and panel discussion on legal consideration for ASEAN Free Trade Agreement by Professor Dr. Sakda Thanikun and Mr. Andrew D. Mastin. Second part will be a presentation session by outstanding present in various topics. Therefore, This conference will provide us not only essential knowledge, but also a great opportunity to share experience legal issues. I would like to take this opportunity to express my sincere thanks to the organizer and in particular our honorable speaker. I hope that everyone would like to take result of this conference to comprehend legal and regulatory system for sustainable development, especially in ASEAN perspective. Finally, this is an opportune time for me to declare the official opening of the first International Conference of Law for Sustainable Development and ASEAN Perspective. And I wish this one fruitful day of interesting and beneficial program, and also that you have a pleasant stay in Bangkok. I warmly welcome you again.
Thank you, Professor Banjit, for granting us such a warm welcome. Now, please allow me to invite Associate Professor Kampon Panyagomed, Vice President for Research and Consulting Services, to give us an opening address.
So, good morning, everyone. Dear Dean of Graduate School of Law, honorable speakers, distinguished guests, faculty members, ladies and gentlemen. On behalf of National Institute of Development Administration, I would like to declare that the first International Conference on Law with Sustainable Development and Asian Perspective is now open. At this special moment, it gives us a great pleasure and privilege to welcome all of you from abroad and within Thailand. Therefore, I would like to express my gratitude and a warm welcoming to our panelists and featured speakers, as well as the presenter, especially those who are coming from overseas. Now, please allow me to say some words about the theme of the conference. The conference adopts a timely theme titled Law with Sustainable Development and Asian Perspective. The wide dissemination of sustainable development in law has generated considerable academic interest. Sustainable development has played an important role to widely penetrate the legal domain. However, sustainable development does not belong to law. It may be a vital, philosophical, or political objective, but it is not a legal one. Its connection with the law is restricted to the fact that it may contribute to law formation. Therefore, the focus on law as a development policy share a great deal with other efforts to replace political and economic thinking, with a general appeal to technical expertise ideas about best practice. The conference will also be concerned with the importance of the legal effects on sustainable development, emphasizing on the need for inclusiveness of the diversity among ASEAN countries. Balanced and sustainable economic growth within planetary boundaries and human rights should be respected. Furthermore, I need to highlight the urgency of pursuing sustainable and inclusive development paradigms in which the three pillars of law with sustainable development are integrated in ASEAN communities. I do believe that the surprising thing about the law and development today is the emergence of these simple images within the legal field. The law of law is regarded as the key driver of integration, particularly in its early years of moving barriers to trade. If you look at the conference program, you will agree that this inaugural conference is going to be productive. There is a lot to offer for one-day event. In closing, I hope that all of you will enjoy the conference And I wish our visitor from abroad will have the very pleasant stay in our country. Thank you very much.
Thank you, Professor Kampon, for giving us an insight into the overall framework of today's conference. Without any further ado, please allow me the honor to introduce our keynote speaker, Dr. Sujarikun. Dr. Thanet Sujarikun. Dr. Thanet Sujarikun has been actively involved in international law and diplomacy since his study in the United States for over 30 years. Subsequent to his graduation with a bachelor degree in law from Thammasat University in Thailand, he had graduated from Washington University with a master in comparative law, a master of laws with highest honors in international and comparative law, and a doctor of judicial science, the last two as a Fulbright scholar. He was assigned by the Ministry of Foreign Affairs to work with the Ministry of Commerce in the permanent mission to Thailand to the World Trade Organization as a legal advisor, where he actively engaged in various diplomatic functions of the World Trade Organization. Dr. Sujarikun is now the director of the Master of Arts program in International Law and Diplomacy of the Assumption University of Thailand, and has been teaching in several subjects relating to the international trade and economic law, such as international trade law, international business law, investment law, electronic commerce law, and ASEAN law in several universities in Thailand, in addition to the Assumption University, such as Chiang Mai University, Chulalongkorn University, Naresuan University, and the Maphalong University. Ladies and gentlemen, I give you Dr. Thanet Sujarikun, your keynote speaker.
Good morning, ladies and gentlemen. First of all, I would like to thanks very much for NIDA to invite me to share some of the information pertaining to ASEAN. Okay. It is indeed an honor for me to be here once again. I have been here several times before. And today, my task is to talk, first of all, about the legal perspective pertaining to ASEAN. Okay, because the theme of this conference is ASEAN perspective. And as I'm a lawyer, I would like to talk to you about ASEAN legal perspective. And when we are talking about legal perspective, there are several issues that we have to consider. One of them is organizational structure, whether or not ASEAN is an association or whether it is an international organization. This is a new development in ASEAN. And secondly, when we are talking about ASEAN, sometimes we have to think about economic integration. Because in ASEAN, one of the objectives of ASEAN is to achieve the so-called, at the very beginning, after. Okay? Before that, we have PTA, ASEAN Preferential Trading Arrangement. And after that, in the year 1992, we launched the so-called ASEAN Free Trade Area, ASEAN Free Trade Area, or AFTA. Okay? And after that, in the year of 2003, after we have accomplished the so-called AFTA, we have the ambition to go further to be ASEAN Economic Community. So we are going to consider what does it mean? What does it exactly mean by AEC, ASEAN Economic Community? The third one, of course, we have to talk about dispute settlement mechanism, which in the past we have only consultation and consensus to settle the issues. Okay? But now, since the advent of ASEAN Charter in the year of 2008, we now have several mechanisms to settle the dispute. But I don't know if I have enough time to go into details. But if not, the best way is that I have a paper which I have done a few weeks ago in order for you to follow or to proceed further because my time is limited only to 45 minutes. Okay? And after that, one thing that I would like to mention is that FTA or Customs Union or CU is a kind of exception to the principle, the cardinal principle of the GATT, General Agreement on Tariff and Trade, or even all kinds of agreements under the World Trade Organization. The cardinal principle is non-discrimination, and it is a kind of non-discrimination which is unconditional. Whenever any member of the World Trade Organization accord any special treatment to any members of the World Trade Organization or even non-member, they have to accord the same treatment immediately and unconditionally to all other members. But FTA, like AFTA or AEC, is a kind of exception. Okay, but we are not one of them in the world. We have several of them. Before the creation of the World Trade Organization in 2003, we have only three. We have EU, of course, which is a kind of customs union. Secondly, we have NAFTA, North American Free Trade Area. And we have the honor to be the third one after ASEAN Free Trade Area. But after the creation of the World Trade Organization in 2003, as I have heard the statistic, we have about 500 FTA. Now, that's the statistic in 2003. But now we have 2016, I think it's more than 1,000. Okay. What would happen if the discrimination is the rule and the non-discrimination is the exception? Okay. An interesting thing that we have to think of ourselves, the ASEAN. We all members of the ASEAN, all member states of the ASEAN, we are all members of the World Trade Organization. But at the same time, we have several bilateral FTA with also countries. Thailand as far as or as much as 12. For example, with Japan. For example, with Chile. Singapore is not lag behind. They have several more too. Okay, and several other countries in ASEAN too. What would happen if we have overlapping FTA? Okay. What should be the rules? What should be the rules to be applied in case of Thailand and other countries in Asia or in ASEAN? Okay. We call this phenomena as proliferation of FTA. And it would hurt the multilateral trading system in the World Trade Organization. Okay. And in ASEAN, we also have the principle of so-called ASEAN Centrality, which means that even though we are going to be ASEAN Free Trade Area, even though we are going to be ASEAN Economic Community, but we are looking outward. Looking outward is that we are not across economic groups. We are not going to trade among ourselves only, but we are going to trade with the outside world. All right? And in order to trade with the outside world, we should act as a united front. And therefore, we have the principle of so-called ASEAN Centrality. Okay? And now, I think this principle is very challenging for ASEAN because ASEAN, as I have already stated before, that not only that we are members of the ASEAN, we are also members of several FTA. Okay? We are not actually act as united front. We are not act like ASEAN Centrality. And very recently, the most challenging phenomena is that there are two regional trading arrangements, I so-called. The one is TPP, Trans-Pacific Partnership, led by the United States. And at the present time, as far as I know, 4 ASEAN member states are the participating countries in the TPP, and that is Brunei, and it's Malaysia, Singapore, and Vietnam. And at the same time, ASEAN has already initiated ourselves to have the so-called RCEP, Regional Comprehensive Economic Cooperation, right, which comprise ASEAN and 6 countries. ASEAN plus 3 first, like Japan, China, and Korea, and plus India, Australia, and New Zealand. Okay, so we have to think about ourselves. What kind of organization we should join, right? If we join both, then we may exacerbate the problem of FTA proliferation. Okay, that's all that I think I should speak to you. I should also speak to you about the success of the ASEAN. Are we success as we contemplate in 1967? Okay, so I should start first with the organizational structure. ASEAN was created in the year of 1967 in the midst of communist expansion. 3 countries in Southeast Asia at the time was about to be socialism or communism, and that is Vietnam, and that is Laos, and that is Cambodia. Okay, and at the time, during the year 1960, there are 2 big countries, major countries, which adopt communism. One is Soviet Union, which was very big at the time. It was not disintegrated yet. And the second one is China. Okay, the 2 countries has the ambition that the whole world should be turned into communism. All right, and they would like to expand their influence into Southeast Asia too. How can the rest of countries in Southeast Asia, the 5 countries at the time, like Thailand, like Malaysia, like Singapore, like Indonesia, and like the Philippines, how can we cope with the situation? Can we fight with the big countries like China and Soviet Union? Probably not. But at the time, we was lucky because one of the major countries in the world, and that is the United States, which advocates so-called free trade and individualism. Their philosophy is very much different from communism, and they helped the 5 countries. But all of a sudden, they said to us that I have to withdraw because our population in the United States would not like us to be too much preoccupied with the war or with the affairs in this part of the world. So they would like to withdraw. So the 5 ASEAN member states has probably a very few choice. How can we do? So we thought that we should getting together. But at the same time, we are reluctant. We would not like to create the so-called international organization because virtually all countries in Southeast Asia except Thailand were under colonization at one time. And they have never experienced something like freedom before because some country was under the rules of major countries for 1,000 years, something like that. So what they cherish very much is sovereignty, political independence. So they would not like to create a so-called international organization whereby we have a central organ to administer. So we form in a very loose manner. So we call association, as the name indicated. Okay. The major mechanism for ASEAN for the administration is only the meeting of the foreign minister. But unfortunately, we have quarrels among ourselves, like between Thailand and Cambodia, between Malaysia and the Philippines, between Malaysia and Singapore, and between Malaysia and Indonesia. Most pertains to territorial disputes, which was the result or was something west upon the region by colonizer. Okay. we cannot, we could not hold a meeting of the foreign minister for 9 years, 1961 until 1976. So 1976 was the first time that we were able to convene the first ASEAN foreign minister. And at that meeting was very, very important because so the first one is that we lay down the groundworks for cooperation in all fields, whether security, whether political, whether legal, whether economic, whether social, or whether cultural. We lay down the framework we call Bali Concord 1. Okay? And after that, we also adopt the ASEAN instrument, which is very important, and that is the TAC, we call it in short. The long name is Treaty of Amity and Cooperation in Southeast Asia, which is very long, nobody can recognize, so we call it TAC. And TAC is still in force, and it is one of the main dispute settlement mechanisms under ASEAN at the present time. And it is the only one ASEAN instrument whereby outside country can be a members. The number of members or contracting parties, I should say, to the TAC is now more than 20 countries. The 5 major powers, nuclear power state and Permanent Security Council, all 5 are members. North Korea, South Korea, India, Pakistan, Japan, all countries are members of the TAC. And it is interesting to note that the TAC has a dispute settlement mechanism, which in theory can be used to settle the dispute among China and the 4 ASEAN member states in the South China Sea. But whether or not they are going to use it, I cannot say at this moment. Okay? The turning point for ASEAN, I think I should summarize because the time is limited. 2008, the ASEAN member state adopt the so-called ASEAN Charter, and that is the turning point organizationally speaking because it turns the association into the international organization. Why I say that? Because according to the theory of international law, before any institution or any organization can be treated as international organization, it has to have 2 legal personality. The first one is international legal personality. Another one is domestic legal personality. We have both at the moment. Article 3 of the ASEAN Charter say that ASEAN as an intergovernmental organization shall have legal personality. Unfortunately, it doesn't say explicitly whether it is international legal personality. It is says so. But when we read it in conjunction with Article 41, paragraph 7, which say in a sense that ASEAN can conclude a treaty with other states and with other international organizations in all levels. So when Article 3 read in conjunction with Article 41, paragraph 7, as I have already stated, we can conclude that ASEAN at the moment we have the capacity to conclude a treaty. Okay, but before the ASEAN Secretary General can conclude a treaty, it has to get the approval first from the ASEAN member states, which have never been approved. Okay, but in principle, we have the capacity to conclude a treaty. Insofar as domestic capacity, domestic international legal personality is concerned, it is not listed in the ASEAN Charter. We have it in the separate agreement, and we call agreement on privileges and immunities of the ASEAN. It was concluded in the year 2009 by virtue of Article 25 of the ASEAN Charter. Article 1 of that agreement says that ASEAN shall have domestic legal personality, which means that it can conclude a contract, not a treaty, contract. It can acquire or dispose of movable property or immovable property, and it can instill and defend itself in a legal proceeding. When we have these 3 conditions, it means that we have domestic legal personality. All in all, we can say that at the present time, we can safely say that ASEAN has changed from association to international organization. We can be regarded as we are successful in this sense. Okay. Now we turn to the second point, whether or not we are truly ASEAN economic community. When we talk about economic integration, the first one that we attempt to accomplish is the AFTA. Yeah. The AFTA was launched in the year of 1992. The starting point is the 1st January 1993. The main mechanism to bring about the target of being free trade area is an agreement which we call CEPT, Common Effective Preferential Tariff. The CEPT is nothing more than the way how can we reduce or eliminate. We have two words, reduce or eliminate tariff. At the 1st January 1993, we say that any tariff of any member state of ASEAN at the time, 6 member states, okay, which more than which were more than 20% ad valorem, has to be reduced to 20% ad valorem by 5 years, starting from 1993. So by the 1st January 1998, virtually all tariffs which were traded among ASEAN member states has to be reduced to 20%. And after that, starting from 1st January 1998 to 1st January 2003, 5 years, the 20% has to be reduced to 0 to 5%. Okay? So by the year 2003, 1st January 2003, we can claim that we achieved the so-called AFTA because virtually all tariff that we are trading, tariff on the trade in goods that we are trading among ASEAN member states are reduced to 0 to 5%. Okay. By the year 2000, as I've already said, that we have the ambition to go further. We said that no, we are not going to live with only 0, 1, 2, 3, or 5%. We are going to achieve those called zero tariff. Okay. We claim that by 2015, virtually all trades shall have no tariff. Okay, no tariff. The tariff, instead of 1, 2, 3, 4, 5, shall be 0. This is the distinction between AFTA and AEC. But my point is that for legal discussion, I just would like to mention that all FTA in the world has to be has to comply with the conditions set out in the GATT, General Agreement on Tariff and Trade. In particular, Article 24, Paragraph 5 and Paragraph 8. Starting from Paragraph 8 first. Paragraph 8 says that any economic integration, before you can claim that you are FTA, you have to prove that among yourself, duties and other restrictive regulation of commerce, except, Article 12, Article 13, Article 14, Article 15, Article 20. It doesn't mention about Article 19, which I will say the importance of it, the implication of it, shall be eliminated in substantially all the trade. They use the word eliminate. They just don't use the word reduce. So eliminate, in my understanding, is that virtually all trade must be reduced the tariff into zero. But after, in the year of 2003, we still have tariff, not 0, 1, 2, 3, 4, 5. I don't know what was the majority of them. 90% or 95% of the tariff, maybe 5%, I don't know. If that is the case, we not fulfill the requirements of Article 24, Paragraph 8. In order to fulfill Article 4, Paragraph 8, virtually all trade must reduce the tariff to 0. Okay? If that is the case, when we think about AEC probably fulfill the requirements of Article 24, Paragraph 8, because we are going to achieve 0 tariff, all right? Then we can fulfill duties and other restrictive regulation of commerce shall be eliminated 0 in substantially all the trade, So, if that is the case, I think most people, especially in Thailand, when we are talking about AEC, we think beyond FTA. We think that AEC will be in a similar manner as the EU. But in fact, it is very much different. One starting difference is that in AEC, we do not have common external tariff in the same manner as the EU has, which means that respective member states, whether Thailand, Malaysia, Singapore, Indonesia, can still have separate external tariff with respect to outside member state. For example, Malaysia may collect duties for foreign car imported to Malaysia like 500% ad valorem. Thailand may collect 200. Singapore may collect 0. That can be done under the AEC. If that is the case, we cannot claim ourselves to be the same as the EU because the EU have common external tariff. We cannot even be something like custom union because in the term of custom, one of the requirements is that you have to have common external tariff. And what I would like to trigger the thinking, maybe the second panel, Dr. Sarda will also participate in the second debate. I would like to mention that Article 24, Paragraph 8, there is exception to the reduce or the elimination of duties and other restrictive or regulation of commerce. They mention an exception, Article 12, about balance of payment deficit. Article 13, 14, and 15 deals with non-discrimination. Article 20 deals with general exception, but it doesn't mention Article 19. Article 19 deals with safeguards. What does it mean by safeguard? Safeguard is that when we are open our markets, we reduce the tariff to 0. But what would happen if all of a sudden we did not anticipate before? Imports of foreign flood into our countries and make our country serious injury. Okay. Article 19 of the GATT say that if that is the case, if you can prove injury and the injury to domestic producer producing like or directly competitive products, then you you have the right to adjourn. You have the right to withdraw, or you like to have to change the agreement that you have done, right? Maybe you can, okay, I cannot live with the reduction of tariff. For example, we may agree with our trading partner. We would like to reduce the tariff for the importation of rice from 50% to 30%, but all of a sudden, the rice from our trading partner flood into Thailand. We say that we did not anticipate that before, unforeseen. Secondly, there is a surge of import. And thirdly, our domestic producer suffer serious injury. If that's the case, we can adjourn, or we can withdraw, not to do anymore, or we can amend, or we can change. Okay, that is Article 19 of the GATT, but it doesn't mention in Article 24, Paragraph 8. What I would like to say here is that, legally speaking, theoretically speaking, if you are going to be the FTA, there shall be no safeguard at all theories, but none of the FTA has complied with this requirement. Now, talking about ASEAN, it is very interesting that ASEAN has as much as 5 safeguards. The normal safeguards is very similar to Article 19. But we are very reluctant to reduce the tariff. We say that, okay, if we are going to reduce the tariff beyond 20% to 0 to 5%, we have to have 4 schedules. I don't like to go into details. The first one is inclusion list. The second one is temporary exclusion list. The third one is sensitive list. The fourth one is highly sensitive list. Okay? The first one only that we are agreed to reduce the tariff. So any countries that ready by the year of 1992, they throw all the goods into the list one, inclusion list, and then they reduce the tariff. The second one is the one that we are not going to reduce at the time 1993, but we need time, maybe 5 years from now, from that time. 1998, we are going to reduce, like Malaysia has done. They assign like CBU, completely built up car, and CKD, completely knocked down car, into that schedule, TEL. Okay? And in TEL, they have one special safeguard. What would happen if I have already assigned my, if I have already put my goods into the second list, TEL? What would happen if we experience real problem? We have special ASEAN instrument say to the effect that if you experience real problem, you do not have the obligation to transfer the products in the second list into the first list, okay, in the first place. But if you are unlucky, you have already transferred from 3, 4 to 2, and then from 2 to 1. Then, in principle, you cannot transfer it back. Okay? If that is the case, you just don't have to do anything. Just put it in there. Okay? This is the safeguard. Safeguard in TEL. This is the second safeguard. Okay? The third safeguard is any products which in the fourth list. Fourth list is highly sensitive list. If you put sugar, if you put rice in there, you don't have to prove serious injury. Once you can prove only that 3 years before that, the average of the importation of rice into your country, 3 years before that, how much are they? For example, the average 3 years before we have the problem, we import rice like 5 million tons into Thailand. The one beyond 5 million tons, you don't have to prove serious injury. You can collect any tax which you like, maybe the same as before, or MFN tariff rates. Okay. And with respect to sugar and rice, we have special rules, special safeguards. If all kinds of safeguard, 1, 2, 3, as I have already mentioned, doesn't work, you can ask for a waiver. You can ask for a waiver, which normally the ASEAN member states are very flexible. If you ask for a waiver, we normally grant. Okay, all of them are still exist in the ETICA, ASEAN Trade in Goods Agreement. Okay, in Article 23, we say that if you have experienced problem, then you can use the normal safeguard. Then you can use the rice and sugar safeguards. And if all the safeguard doesn't protect you anymore, you can prove only that we have unforeseen difficulties. If you can prove that unforeseen difficulty, you have the obligation to do anything. Okay? Unforeseen difficulty is very flexible indeed. What does it mean by unforeseen? What does it mean by difficulty? Is it economic difficulty, political difficulty, or a security difficulty? There is no rules on that. So what I'm trying to say here is that we have an aim to reduce the tariff to 0. We have the aim to liberalize our laws and regulations, but at the same time, we can live out of obligation by means of safeguard very easily. So whether or not the AEC will be successful depends on the determination, the political will of the ASEAN member state. Okay. Now, I should turn to the proliferation. All right. The proliferation, at the present time, I have listed a large number of economic cooperation. One of them is the Y project. The Y project is the transportation link between a city in Myanmar to a city in Cambodia. So if this project is successful, we can shorten the maritime routes from China, from Japan. You don't have to go down further to Singapore and go to Indian Ocean. Okay, we can stop. You can download the goods in the city in Cambodia and then transport by land to the Y or vice versa. Okay, another one which is already the program in ASEAN is Singapore Kunming Railway, high-speed railway. It was claimed that if the program is successful, it will reduce the traveling time from Kunming to Singapore within 10 hours. If that is the case, it will boost a lot of tourism, right? It will boost a lot of trade, and Thailand, as the center of the region, will benefit from it, I say. Yeah. We have also Greater Mekong sub-region, okay, which is cooperation among riparian states of the Mekong River. We have several agreements pertaining to that. One of them, which I was to work with it, is Mekong River Convention, MRC, which regulates the use of water, Mekong water. Some country would like to divert water for agriculture, so we have rules on that. We have rules on the use of the river, for transportation. At one time, we have a fierce debate with China because China would like to construct the dam. China is the up riparian state, right? So if that is the case, it may affect the lower riparian state. So we have the talk with China. So it can be a source of cooperation, and at the same time, it can a source of dispute between the two countries. Recently, we have also Pan Baibu Gulf, which is very similar to Singapore Kunming Railway, right? But now it's Nanning Singapore Economic Corridor, which comprises two wings, GMS and PBG. I just don't like to dwell into these, so you can read it. Okay. And one thing that I would like to mention about Thailand is that we are very lucky because we are situated in the middle of the mainland ASEAN. Okay, surrounded by 4 countries. Okay, and as such, we can avail ourselves of the advantage of one of the very important principles of the GATT, and that is even the GATT, General Agreement on Trade in Services. GATT is General Agreement on Tariff and Trade, deals with goods. GATS is General Agreement on Trade in Service, deals with services. All of them. And in the ASEAN instrument too, ATICA, the AFAS, all of them recognize foreign trade traffic, which means that a country can accord special benefit to neighboring countries without having accord the same benefit to outside country, or even ASEAN member states which do not have common frontier with Thailand. Okay, if that is the case, we are very beneficial from that. So we can accord special treatment without having to conclude any special agreement, because it's the provision already provided for in all agreement under the World Trade Organization, in all ASEAN instruments. Okay, and we have also ASEAN Power Grids. The main purpose is to achieve the so-called greater regional energy security and sustainable development, and to reduce dependency of fuel imports from non-ASEAN member states. We also have Trans-ASEAN gas pipeline cooperation in terms of transportation of a very important product, and that is oil and gas. And Trans-Pacific Partnership, which I have already mentioned. This is one of the challenging about ASEAN centrality. At the moment, it comprises 12 participating states. It represents 11% of the world population, 40% of share of the global trade, and 38% of the world GDP. It is remarkable to note that as of now, as I have already mentioned, 4 ASEAN member states, namely Brunei, Malaysia, Singapore, and Vietnam, are joining the negotiation. Would it mean that we exacerbate the existing problem of FTA proliferation? Would it be overlapped with rights and obligation under the ASEAN? Would it divert ourselves or reduce or attenuate ourselves with unity among ourselves, ASEAN centrality, or something like that? That's the thing that Dr. Sakda and the rest will discuss. I just would like to just raise the issue or set the tone for further discussion in this forum. Okay? And at the same time, I have already mentioned about the RCEP, Regional Comprehensive Economic Partnership. It is very interesting that in terms of population, we account only as much as 50% of the world population. What about the share? For the total 16 member states, 29%. And what about the GDP? 28% of the world GDP. And we have a large number of programs to be accomplished, and it contains in the guiding principle of the object for negotiation of the Regional Comprehensive Economic Partnership. What we are going to trying to achieve is that it will be consistent with the WTO obligation, especially Article 24 that I have already mentioned. And it has to be broader and deeper engagement with significant improvement over the existing ASEAN +1 FTA. We have, I think, all ASEAN member states have as much as about 20 to 30 bilateral FTA. So if we are going to have RCEP, we are going to go beyond, deeper and broader. It is the intention. I don't have the time to go into detail. Now, turning back to the ASEAN centrality, it is interesting to note that the guiding principle states very explicitly that ASEAN should be the center of negotiation and cooperation. They say that negotiation, preamble paragraph 2 of the guiding principle. You can take a look at the source down there in the footnote. Preamble paragraph 2 say that negotiation for RCEP will recognize ASEAN centrality in the emerging regional economic architecture and the interests of ASEAN FTA partners. So here is the ASEAN centrality. Okay, it's mentioned. If that is the case, if it is clearly provided in the guiding principle, and the trading partners, including the outside ASEAN member state, adhere to this principle, it would mean that ASEAN will act as a center, ASEAN centrality. But ASEAN centrality is one thing, but the substance of the agreement is different. Because if you can be the chairman, if you can be the host of the negotiation, it doesn't mean that everything can be under control. It depends on the negotiation. Okay. The success of ASEAN, I have already stated. Okay. And the centrality of ASEAN, I think what I can conclude here is that ASEAN can so far achieve some success in terms of organization. We are success also in terms of economic integration, whether it be AFTA or whether it be AEC. But in terms of centrality of ASEAN or ASEAN centrality, it remains to be seen, even though it is stipulated in the guiding principle for the negotiation. But whether or not the ASEAN can reap the benefits of the guiding principle remains to be seen. Okay. Can it be the center for economic cooperation? This is another issue. It's different from ASEAN centrality, but it depends on the location, physical location. You cannot do anything about the physical location unless you can move the country from one part of the world to another. Okay? So at this part of the world, in Southeast Asia, Southeast Asia stay in the middle. If you would like to cooperate in terms of logistics, you cannot just bypass Thailand and Cambodia and Laos and Myanmar. You have to pass, right? East, south, north, west, yeah? or north, south, east, west. You have to pass Southeast Asia. If that is the case, it's not a legal problem. It is the factual problems. Okay, and I think we remains to be benefits from our physical location, especially in terms of foreign trade traffics. Okay. Now, I would like to end because I have only 5 minutes from now. I just would like to put the legal issues for the second group to debate, okay, in terms of market access. Okay. ATICA is the main instrument to bring about the AEC. The ATICA deals with trade in goods. As of now, we have as much as 8 schedules for liberalization, but only one, I think only one of them, I think you have to see the footnote, only one of them, Schedule A, account for 80%. ASEAN member states have the duties to eliminate tariff to zero. Schedule B and C applies to, I should put it here in order to make it clear. I don't have much time, so I have to very quick, but I can pinpoint about the schedule. I hope that you can see, right? Schedule A accounts for 80% of all products, but in 80% include ICT product and PIS, priority integration sector, like rubbers, like wood products, something like that, okay? Has to be eliminated. You see eliminate here. B, C deals with CLMV, Cambodia, Laos, Myanmar, and Vietnam. Has to be eliminated, but 80% also. But Schedule D, you can have the choice at your own volition, at your own accord. You can reduce or eliminate, or you can do not at all. Not at all. It depends on your own accord. The same applies to Schedule E, okay? Unprocessed agricultural products, okay? In F and G deals with Thailand and Vietnam and Cambodia about tariff quota, which I don't have time to elaborate further on. But Schedule S is very important and very interesting because we put the exception as a rule. Normally in the GATT we have an exception and Article 20, but before you can invoke Article 20, you have to prove, you have the duty to prove that you have to undertake the pressure because it is necessary. Measure necessary to protect human, animal, or plant life or health. Measure necessary to protect public moral, A. And measure relating to conservation of exhaustible natural resources, you have to prove, okay? But here, you just put it beforehand. If this is the goods that you are going to import into country, we will regard as the goods that may affect public moral. This is the good that may affect human, animal, or plant life or health. So we put it beforehand. So it's a general rule rather than the exception. Okay. This is one of the issues that you should take a look now. And then I have already mentioned about safeguards. Legally speaking and theoretically speaking, if you are going to be FTA, you cannot have safeguards. But in the actual reality in the world, every FTA has safeguards. But in ASEAN is more interesting is that we have as much as 5 safeguards, and our safeguard is very flexible. because Article 23 of ATICA say that if you experience balance of payment deficit, if you are suffer from flood from rice and sugar, or if you can just prove that we experience unforeseen difficulties, you can do away with your obligations. You can adjourn your obligation, you can withdraw your obligation, or you can change your obligations. Okay. If that is the case, if we are not pertinent in our measures, then it would be very difficult for the AEC to be accomplished. All right. But I'm not going to say that when we have Article 23, AEC will be not successful. I'm not going to say that because it can be a kind of incentive too. Because a country may be more willing to open their markets because they know that in the last resort, if we have real problem, if we have unforeseen difficulties, we can do away with our obligation, at least temporarily. Okay. And non-discrimination, it is very interesting to note. If I have just 2 or more minutes, it's very interesting. Because under the World Trade Organization, you cannot discriminate at all because we have unconditional non-discrimination. But under the ASEAN is very interesting in terms of trade in goods. We have Article 5 of the ATICA. Article 5 of the ATICA say that after the conclusion of, after the entry into force of ATICA, if a member state has concluded or have accord special treatment to outside member state, for example, with respect to cars, in ASEAN we have common tariff like probably 200%, but all of a sudden we accord special treatment to Japanese car like 100%. It doesn't mean that other ASEAN member states will get the same treatment like Japan. So Japan may have more benefit than ASEAN member state. This is a very unique and very interesting. They say that ASEAN member state has only the right to request the same treatment, but whether or not the granting treatment will accord that kind of treatment to the ASEAN member state is unilateral basis. You yourself will decide. But once you grant, you have to grant to all. Okay. The same applies to AFAS. AFAS is a kind of trade in services. We have the rules now. Since the involvement of the CRMV, we have the rules that we have the ASEAN minus X, which means that ready ASEAN member state in terms of services, we can conclude agreement among ourselves, but the benefit that we accord to each other will not go to the rest of ASEAN member states right away. The other ASEAN member states can have only the right to request the same special benefits. But whether or not the ready member states are going to accord depends on voluntary basis, on the voluntary basis. For example, like mobile telephone operator of the 3 countries like Thailand, Singapore, Malaysia are ready to cooperate, which means that mobile telephone operator in each country can operate in any other country right away. It doesn't mean that this benefit will go to Vietnam or to the Philippines. Okay, Vietnam, Thailand, can you accord the same treatment that you accord to Malaysia and Singapore? Thailand have to consult Malaysia and Singapore whether or not to accord the same treatment to Vietnam. All right, it depends on voluntary on the part of the participating ready member state. But once you accord to Vietnam, you have to accord to all. Okay, so this is challenging for ASEAN. I think I have a lot of things to do, but since in the rest of time, I don't have much time to do that. Before I conclude, I can say that AEC, ASEAN Community, is a misnomer. It is not a community in the real sense of EU. It is just FTA. Everybody accept that. And in terms of decision making, normally in the past, everything has to be done by consensus. But with the advent of ASEAN Charter, we have special provision, Article 22 say that in case the consensus cannot be achieved, the ASEAN Summit can make a ruling whether or not we will use another mechanism for making a decision. But the big point is that before you can use another main mechanism, beyond consensus, it has to be decided by consensus too, whether or not to vote, things like that. So I would like to end at this point, and I don't have much time. I hope that you can read this paper in order to, to go beyond what I am talking. And I'm very glad and indeed very honored to be here today. Thank you very much.
Thank you very much for Thanajaan Thane to give us such an interesting, insightful, and very refreshing views on the legal perspectives of the ASEAN community. On this regard, I would like to invite Thanajaan Banjert for giving, on behalf of us, to express our thanks and to present him with a souvenir as a token of our appreciations to Thanajaan Thane. Ladies and gentlemen, I believe we have quite a very interesting event this past morning. Now it's time for coffee breaks. The refreshments will be served outside this room, and the session will resume again at 10:45.